I feel like harassment is one of the areas of employment law that is most misunderstood by the public. Harassment is also known by the phrase hostile work environment. And people have the perception that if their supervisor is nasty, is abusive, is unpleasant, is hostile in the general sense, that that's unlawful. Unfortunately, that's not true. For there to be unlawful harassment or an unlawful hostile work environment, the employee has to be targeted because of a protected characteristic under the anti-discrimination laws or because of a protected activity under the anti-retaliation laws. So most commonly, we're dealing with cases of sexual harassment or a hostile work environment based on sex or gender, but it's not limited to that. That's the area that the public is most aware of because it's been discussed most often in the news, in movies, and books. But there can be a hostile work environment based on somebody's race. There can be a hostile work environment based on somebody's religion. There can be a hostile work environment based on somebody's disability. There can also be a hostile work environment based on a protected activity. For example, if the employee has blown the whistle on conduct that violates, for example, SEC regulations in the finance industry or FDA regulations in the pharmaceutical industry. If they're then not subject to an outright adverse employment action like firing or demotion or suspension, but instead, they're being made to work longer hours. They're being given the less desirable assignments. They're being ostracized by their supervisor and their coworkers, treated differently in the terms and conditions of employment. That's what would be harassment or a hostile work environment. And so in general terms, regardless of the type of protected characteristic that you're dealing with, the harassment or hostile work environment has to be targeted at the employee because of the employee's legally protected characteristic under the anti-discrimination laws, for example, race. The way that they're being treated has to be either severe or pervasive. So severe could mean one incident that's really bad. So here in New Jersey, we had a case that went up to the New Jersey Supreme Court in which a county sheriff referred to a black sheriff's officer to her face in front of other people by a racial epithet. And the racial epithet was serious enough that the court said that one incident standing alone, because it was coming from what amounted to the CEO for that workplace, the sheriff who's elected by the county residents, that was bad enough that standing alone was severe enough to create a hostile work environment by itself. The other possibility is that the conduct is pervasive. So that means it's happening every day or almost every day. Maybe the things aren't as serious, but it's constant. And so it has to be severe or pervasive enough that a reasonable person of the same legally protected characteristic as the employee would feel like the terms and conditions of employment were changed. So in the case of a race harassment claim brought by a black plaintiff, the question would be, would a reasonable black person find the terms and conditions of employment to have been changed in a negative way based on that type of harassment?